when Mr. Gray identified Mr. Burton as a potential witness, the state had filed first an objection. I believe the initial premise was that they hadn't received any reports or background information regarding Mr. Burton and his proffered testimony. I believe that was cured by Mr. Gray in providing a thumb drive or some other type of conveyance to the state, which again outlined, I believe, what the proffer will be in terms of his testimony. I then received an objection from the state requesting what's characterized as a Daubert hearing pursuant to Wisconsin's rules of evidence regarding experts. The state provided what they believed was the basis for that request. Mr. Gray filed either a brief or a letter suggesting that no hearing was necessary and that the court basically should deny the request and proceed to permit that witness to be called. I think, as everyone knows, I err on the side of making sure we have a complete record, and as a result, we'll reserve on Mr. Gray's motion to deny pending what is now going to be the Daubert hearing. We know that under Wisconsin statute 907.02 parent 1, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. If the testimony is based upon sufficient facts or data, the testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. And then there are, again, what the court would characterize as the factors that I'm going to be asked to consider. My first question, Mr. Gray, is Mr. Burton going to be offering opinions or simply reporting what the results of his testing were? And if you understand my distinction.
Yes, I understand. Well, we would like to do both.
Okay, so, and the reason being is that if he's not offering opinions, it's not going to be a Daubert issue. But in fact, as I understand, he did some testing, and you're going to ask him to render opinions based on that. So,
Judge?
Yes.
Let me go out and talk to him a minute, and I might just, I don't think.
Let's take 5 minutes, and we'll come back in. Thank you.
All rise.
Record should reflect again that we're in session outside the presence of the jury, and we were, I think, discussing the nature of Mr. Burton's testimony and if in fact he is a fact witness reporting facts as opposed to an expert who may be rendering opinion. So, Mr. Gray, what is the offer?
Well, Your Honor, we will go on the fact aspect of it, but there's one problem. In his report, the first paragraph of the page 3, we have to excise that or take it out or something. And I'd like to introduce this. So with that, and we've got a thumb drive with the 2 videos on it, which we have, and he knows how to run that stuff. So yes, we'll agree to just no opinion.
Thank you. And as I understand, for purposes of the offer of proof, the court can rely on the resume as well as the certifications, and that was submitted as part of the proffer. Mr. Kaiser, your thoughts?
Thank you, Your Honor. I appreciate that. Looking at 907.02 sub 1, the couple of propositions that the statute puts forward for us to consider are whether or not there's scientific, technical, or specialized knowledge. And so I was looking when the court asked this question about results or facts versus opinions to try to see how I try to discern that distinction in the statute. And so I'm looking at sort of the middle of the statute where it says may testify as an expert if they're qualified, which is interesting. But just going right to the question of opinion, the statute says thereto in the form of an opinion or otherwise. So in looking to see what otherwise might mean, I look to the Federal Rule of Evidence 702, from which our statute was modeled after, and the advisory committee notes to Federal Rule 702 take that portion of the statute and phrases it this way: is the proffered testimony, opinion, or otherwise based upon sufficient facts or data? And so when I look at the word opinion or otherwise and ask myself the question, what might otherwise be, I think the advisory committee notes to the federal rule help me at least understand that otherwise includes proffered testimony as distinguished from opinion, and our rule does distinguish an opinion or otherwise. So there are 2 different things that are still, I think, required to meet the 5 requirements of the statute. So what we've proffered to the court in our objection is that, first of all, this person doesn't have scientific, technical, or specialized knowledge. His training that he's put forward. Oh, by the way, Judge, one more thing, and I apologize. Going through the analysis, the burden of proof is on the defense, according to Daubert versus Merrill, Dow Pharmaceuticals. And I don't think anyone in Wisconsin is disputing the fact that once the expert testimony is challenged, the burden's on the proposing party by preponderance of the evidence to lay a sufficient foundation. Part of the evidence that there isn't scientific or technical or specialized knowledge is not only the lack of any demonstration of any training in any kind of recreation of pistol recoil type of training, but the certificate which the defense has presented to the court as a basis for his technical or specialized knowledge was a certificate issued for training Mr. Burton went through between January 24th and January 27th of 2020, and I believe his report was prepared in December of 2019. The portion of the scientific, technical, or specialized knowledge makes no reference to any scientific basis for the testing that he's done. Ms. Williams, the firearm specialist from the crime lab, testified that she knows of no scientific basis or scientific testing as out there for this type of testing activity. So that's as to the first requirement. As to the second requirement, whether or not it will assist the trier of fact, the question before the jury isn't whether some erect or set dummy will in fact hold on to or not hold on to a pistol, but whether or not the human being, the person, would hold on to the pistol, and if so, to what degree. And so assisting the trier of fact in this case with that issue, it's our position that it doesn't do so. The third question before the court is his qualifications. As I've spoken a bit to the question of specialized technical knowledge, there being none out there, in addition, he has demonstrated through the submissions from the defense any qualifications as a reconstructionist. Now, we know there are people who are reconstructionists because we've had Trooper Drager testify, we've had Sergeant Coleman testify. These are people who have been trained in reconstructing, and the defendant, Mr. Corey Burton has no such reconstructionist training. In addition, his training is as a shootist, and it's basic police training. It's not training in regards to anything other than what would be basic police training for a person who's shooting. The pistol instruction range safety officer, I'm glad everyone's safe when they're taking range instruction, but being safe at range instruction is not anything that's going to help us understand how the actual reconstruction of a shooting happens. Finally, the defense has received in pages 1482 through 1483 of the discovery that we had to do after we finally got the information about this testing, including Corey Burton's claimed qualifications, and the class that was held in January of 2020, front sight firearms training, was a class that our investigation showed by talking to a guy named Bill Cookston, Cookston, was a training that was a standard 4-day handgun class, equivalent to what a cadet would take in the Nevada Police Academy. It's peace officer standards training certification, so it meets the standards of regulations set forth by the state of Nevada for continuing education for certified police officers. But Mr. Cookston, who ran the front sight firearms training, told us, and I quote, "by no means makes him an expert." The distinguished graduate notation on his certification certified that he was a good shot. And it appears Mr. Burton's wife took the class along with him at the same time. Going to the fourth question, in terms of the testimony itself, whether it's based on sufficient facts or data, it's our position, and we believe we've already established through testimony in the trial, that Heather Williams described and showed the jury that when a person is holding the firearm, the back of the firearm, it goes up against the web of the grip between the forefinger and the thumb of the hand. And in terms of the sufficient facts or data presented in the video, there's no way to see how the pistol is seated in the hand of the thing that this person created. It certainly is not a hand, but there's no way that we ever see how that hand is there. The next thing is, it's an important part of this opinion that Mr. Burton relies on, where he says on the second line of the report from December 19th, 2019, determine the plausibility of a loosely restrained firearm. One of the things that Ms. Williams testified to, and that's an assumption that's made, and it's not only made in Mr. Burton's testimony or report, but it's also made in the doctor who relies on him, One of the things that Heather Williams testified to regarding this firearm was that in order for the firearm to be fired, and she demonstrated it for the jury, for the firearm to be fired, for the empty shell casing to eject, and for the next unfired round to chamber itself, she used the word tightly. A person would have to hold tightly onto the firearm for all three of those things to happen. And we know here that all three of those things happened because we have the ejected shell casing down the stairs, we have the chambered round, and we know the gun fired because Chase is dead. So there's no foundation for his assumption that the gun would be held loosely. And in fact, if one were to have to look for some scientific evidence in this regard, again, having to come up with this since this stuff was filed, my team was able to obtain a treatise entitled Practical Homicide Investigation, Tactics, Procedures, and Forensic Techniques, 5th edition by Vernon J. Geberth, G-E-B-E-R-T-H, whose resume includes decades as a homicide investigator in the city of New York. And he says at page 510, and I quote, "If the weapon is observed in the hands of the deceased, the investigator should examine the hand to see whether the weapon is clutched tightly due to cadaveric spasm, instantaneous rigor mortis. In some instances, the firearm or knife will be tightly clenched in the victim's hands at the time of death due to an intense muscular contraction of the hand." A person attempting to place a weapon in the decedent's hands after death wouldn't be able to recreate that same grasp. Usually when a person shoots himself in the head with a handgun, the weapon will fall from his hand. Without there being any treatise as a basis for the defense assertions here, but yet us having at least some scientific basis for the assertion we've made throughout this case, that the pistol would be found at the feet of the person who shot himself, we believe that there's not sufficient facts or data to support this offer. The other thing is what has been brought to light is the injuries to the finger and the thumb, how that gets to be loosely gripped when those in fact were injured, according to the defense, at the time the victim supposedly, according to them, hurt himself. That couldn't happen during a time of loosely holding on to it. Another fact that is important in this case, and Investigator Mikla emphasized it a couple times during his testimony, is that the recreation of the counter, I'm just going to call it the counter of the island, has only one level. We know from seeing the pictures in our case that there's a counter below the top level of the island. So the fact that the defense attempts to show how things would be with this wooden platform is not in any way analogous to the counter that Chase was either at or seated at the time of the shooting. Another thing that the defense posits that has no factual basis is this bent elbow theory of how the gun was being held. There's just no testimony about that there was elbows bent, that his wrist was bent in any way, and yet that's what's attempted to be recreated. So this thing is asserting facts into this case for which there is no testimony, for which there is no basis, and before it can be admitted and shown to the jury and allowed to prejudice the actual true evidence in this case, these facts or data the lack of these facts or data have to be considered for the court to find that this stuff should be admitted. Another fact that this thing can't recreate are the fact that it is a human being who, according to the defense theory, being replicated by this object, it's a human being that's being hit by this bullet, not this object that was created. And so the object that's created doesn't in any way react to the bullet being fired at it. Yet the human being reacts to the bullet being fired at it. Their head goes back, their neck goes back. And as Dr. Mills testified, the human being falls to the ground and doesn't move anymore. And all of that action, as we all know in our human experience, is connected to one's hands, one's arms. The dummy can't recreate any of those facts, no matter how hard. And if there was ever such a thing out there that would be closer to a human being, we would have not only heard about it from Mr. Burton, because he claims to be an expert, but I believe we would have also heard about it from Ms. Williams, who says that she's never seen or heard of any such scientific or demonstration of any kind. The fifth portion of the statute that needs to be looked at in terms of determining admissibility is the testimony, the product of reliable principles and methods. And reliable means the scientific method. Is it something that's been done before and can be replicated again? And in its replication, is it reliably demonstrating what it's intended to demonstrate? There are no principles, there are no methods, and there's no reliability to it. There's no previous testing of this kind to show that it reliably demonstrates what it's intended to show, which is somehow that the recoil of this firearm time and time again is going to put that firearm not near the person who allegedly shoots themselves, when the experience of all the experts who've testified in this case so far has been, as in the book I cited, that when a person shoots themselves with a handgun, that handgun is most likely going to be found at the feet of the person who does it. And finally, the sixth factor is whether or not the witness has applied the principles reliably to the facts of the case. Well, first we're saying there are no principles, there are no methods, there is no science that's based in this way. But when we ask ourselves, has this been done reliably, one of the most important things we can't see in this video recording is how Mr. Burton went and put the gun where it is. Every time we see a shooting, all we see is him walking away from the person and then sitting down and pulling on this string with the plastic thing attached to it, none of which is anything like a human hand. We don't see what he does to put it there so that we can see where it is and what it is that he's placing it in, so that we can then assess how close is that to the action that would have had to have happened by a human being if it is, as the defense has asserted it is, or is trying to assert that it is with this dummy. So we don't see any application of any methods reliably in this case. And so the burden is on the defense. They've presented you with alleged qualifications, some of which didn't even exist when the test was run. They've presented you with a video recording of some of all of what was done during the testing, but obviously not all of it, since we don't see how it's set up. And finally, we have a test that's premised on a fact, the loosely held gun, which is not only not supported by anything done by the defendant's expert witness to come to that conclusion, but is refuted by the evidence we've received so far in this case. For that reason, Judge, without anything else coming before you, we're asking you, pursuant to 907.02 sub 1, to not allow this to be shown to the jury.
Mr. Gray.
Well, as the court's, excuse me, the court said that the factual testimony and not an opinion. We have 3 people, Judge, testifying that in cases where somebody shoots themselves, the gun drops right to the ground. Three officers testify to that. And all we're trying to do is show that that's not the case if it's an accidental shooting or if the gun flies. We have a trigger finger that has a bruise on it. We have the shell ejected down the hallway to the first floor, and we have a gun that flew 10 feet. We videotaped it, it's reliable. He's open to cross-examination on everything he did, and we're trying to defend this case against 3 people who say, no, the gun would fall down there. And what they're talking about is if somebody intentionally shot themselves. And this is a case where we're not alleging that. We're alleging that the man was on a stool, which we have in this case, the same stool. And Stalkey testified he was sitting on the stool, and he went back to see the pictures, and the gun flew forward by recoil. That's our position. And if you look at the photo, down the hallway where the piece of paper is direct in line with Chase Fleichauer flying backwards. Is it what happened? We're showing that a reasonable inference could be that the reason the gun went maybe 5 feet or 10 feet, we really don't know that. But we have to defend ourselves. And yes, Mr. Kaiser is right. you can't take a gun and shoot it at yourself and test this. That'd be absurd. In fact, I've attempted to convince some experts to even do that, and they wouldn't. We had to use a mechanical person that was constructed. We have it held, it's held tight enough, Your Honor, which is important, and my witness will testify that it's important to hold it tight enough so that a shell ejects, which happened in this case, and another shell is put in the chamber. We have that here, Your Honor. It was held tight enough for that. It's a demonstration, just as a demonstration that they showed in the last trial about the holding the gun, slow motion, fast motion, and the recoil. So all we're demonstrating is, based on the recoil, the gun could have gone that far, or did go that far. So if they didn't have any evidence, well, the gun could go that far if he shot himself. They didn't testify to that. All these experts, experienced officers, oh no, I've been at these scenes, it falls right here. Well, we're going to show that that's not true. That the gun is shot and flies backwards and it'll fly forward. And we're not giving an opinion, he's just going to show the video to rebut what they've said. And I don't see how this could be a scientific matter, Your Honor. It's not. It's the recoil of a pistol that's been going on since the Civil War. So I don't know if this is new or novel. All it is demonstrating the recoil of a pistol. The only way you could do that by having a mechanical person do it. And there's a term for that person that Mr. Burton will testify to.
Thank you. This is, for the court, somewhat of a unique situation in that has been suggested. Are these facts relative to what this witness did, or are these in fact opinions, results, etc., which fall under 90702? And while the court suggested at its opening that it generally has been faced with the situation where an opinion is being rendered, Mr. Gray has now assured and indicated that in fact Mr. Burton will not be asked opinions, but rather will be a witness who testifies to this test that was conducted. So while, again, is this a 90702? I think in part it is, in part it may, in essence, be a deviation, but are these, is this information as well as other knowledge that a common person, i.e. a juror, would have, or is this a matter where other specialized knowledge will assist, in this case, the juror to understand the evidence? And certainly that is what is being argued by Mr. Gray, that this specialized knowledge that Mr. Burton possesses regarding how the mannequin was set up, how it was positioned, how the gun was placed, etc., will assist the trier of fact to understand the evidence. The evidence being, we have a young man dead, feet entangled in a stool, testimony from the crime lab, but that it was their belief that he was sitting on the stool at the time of the shooting. We certainly know the position of the body based on the photographs. We know that an unspent shell was found, as well as the cartridge, the casing for the bullet were found some distance from the body. We know that Officer Sather testified that the weapon was found in the hallway. Again, the court certainly mindful that its exact position was an approximation, and that a piece of paper was used to identify and mark where Sergeant Sather believed and opined the approximate position was. And the court can certainly conclude for purposes of this analysis that the paper, the location, as testified to by Sergeant Sather, was some distance from the young man's body. So the court first is satisfied that the evidence is relevant. I am satisfied likewise that this is knowledge outside the general purview of a lay person, so it doesn't fall under the 907-01 category, but rather will be testimony that is specialized relative to a firearm and what happens when a firearm is fired. Does Mr. Burton have sufficient knowledge, skill, experience, training, education to conduct the experiment, to conduct the recreation that the defense is going to place before the jury? I'm satisfied he does. Is it the product of reliable principles and methods? And again, the court has a hard time posturing this particular evidence into that category because it's not really a matter of principles and methods. It's simply what did he do, as what are the results of this recreation that the defense is now proposing to place in front of the jury. And while, again, parts of what's being offered here I am satisfied may be appropriate under 907-02, it in essence is a recreation. It is going to be a matter of what this witness did with a firearm, with this robot, and what happened to the firearm. And Mr. Kaiser, I am now convinced, has in essence outlined his entire cross-examination of Mr. Burton relative to the test and the other facts in this case, which may challenge his test results as opposed to opinions. As a result, the court will permit Mr. Burton to testify. And again, it is a matter of weight. It is a matter of cross-examination that the jury gives this entire line relative to the test that was done. With that said, let's get Mr. Burton in here and at least try to get as much done as we can before lunch.
Judge?
Connor, we need to fix that exhibit to the opinion portions.
And we can do that. It'll be at least 5 minutes. Mr. Kaiser.
Just wanted to rest on the record.
Yes.
Is that okay? So
And when we bring the jury in, we'll have them do that, Mr. Kaiser.
thank you, appreciate it.
Yeah.
All rise.
3 minutes.
Thank you. We'll break for recess for lunch, and we'll be back at 12:15. Thank you. Well, 12:30, jury's lunch isn't coming till 12, so 12:30, be back, ready to go.
Thank you. All rise.